Everyone, we're just going to wait a couple of moments just to have everybody filter in, and then we'll get started. Okay, so it looks like most people started to filter in now, so we'll get this started. So welcome to our Bill 21 webinar. Before we get going, just some quick housekeeping. This is being recorded. We will make the recording available to you after the webinar. We'll send it out via email in a couple days' time. Your cameras and microphones are off, but you do have the option to ask questions in the Q&A section, and we will have time left at the end for questions. So we'll try and get to as many of them as possible. I'd like to begin with a land acknowledgement today. We recognize that our speakers and participants are joining us from many different places across Canada. While we are not able to acknowledge all the Indigenous lands represented here, we encourage everyone to take time to learn about the Indigenous nations whose lands you are on and the history in your local area. CCLA's office is located in Toronto, which is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, is now home to many diverse First Nations, Inuit, and Métis people. In the spirit of reconciliation, we acknowledge the land that Indigenous peoples have lived on and cared for since time immemorial. We are honored to live and work on this land. With that, I would like to introduce you to our two fantastic presenters today for our Bill 21 webinar. So Harini Sivalingam is CCLA's Equality Program Director, and she's the one heading up the Bill 21 challenge. And Anaïs Bussières McNicoll is CCLA's Fundamental Freedoms Director, and she's also supporting Bill 21's file and is our resident Quebec spokesperson. So I'm going to put their staff bio page into our chat so you can read about their bios, and you can read up on all the staff's bios if you're interested. I'll do that now, but with that, I'll pass it over to you to begin.
Thank you, Michael, and hello, everybody. So as mentioned by Michael, my name is Anaïs, and I'll start us off by discussing what Bill 21 is. So as many of you already know, it's a legislation that was passed by the Quebec National Assembly in 2019, and it prohibits certain public sector employees, such as judges, police officers, lawyers, and teachers, from wearing religious symbols in the workplace. So it applies to religious symbols that are visible, such as hijabs, turbans, kippas, and crosses, for example. And this is a legislation that clearly targets people who express their faith through what they wear. So it definitely ignores the fact that for many Quebecers, wearing a religious symbol is part of their identity. Now, it may, for non-Quebecers, this bill might make absolutely no sense. Frankly, it doesn't make sense for a Quebecer either, but I figured that it would be interesting to give viewers and listeners, the audience, a little bit of context about the distinct context in Quebec. So in Quebec, until the 1960s, the clergy dominated public institutions such as schools and hospitals, and the clergy also controlled matters of morality and even aspects of Quebecers' private lives. And then afterwards, with the Quiet Revolution, the Quebec government, I would say, took its rightful place and in some ways kind of gently pushed aside the clergy. So the key takeaway from this is that there's definitely collective trauma for a lot of Quebecers whenever there is any perceived risk that religion or religious beliefs could take control of public institutions. So for that reason, there is strong adhesion in Quebec to the principle of state secularism, also called laicity, state laicity. Now, courts in Quebec and in Canada teach us that state secularism basically means two things. The overarching theme being the separation between state and religion. So in other words, first, no religion should have any control over the government. And second, the government does not favor or disfavor any religion. Now, the current Quebec government presents Bill 21 as a law that aligns with and strengthens state secularism in Quebec. And the CCLA completely disagrees with this perspective. We believe that Bill 21 is actually going against the principles of state secularism by asking people who wear religious symbols to choose between their faith and their professions. And by doing so, the government is clearly disfavoring some religions in particular. So I think it's a nice segue to pass it over to Harini, who will discuss these impacts in greater detail.
Thank you, Anaïs, for that very comprehensive overview of Bill 21 and Quebec's unique history with secularism. There are a number of rights and freedoms that are engaged by Bill 21, which impact several religious communities, and in particular, Muslim communities, and in particular, Muslim women. Bill 21 engages many rights and freedoms. As Anaïs clearly indicated, Bill 21 infringes on religious freedom by prohibiting certain public sector workers from wearing religious symbols at work. For many individuals, these are not optional accessories, but expressions of sincerely held religious beliefs. And what Bill 21 does is forces people to choose between their faith and their chosen professions. But Bill 21 also engages other charter rights as well, including freedom of expression. Religious clothing or symbols are also expressive. And by restricting what individuals can wear, the law limits their ability to express their religious identity and beliefs. And sometimes those are tied to gender identity as well. As the Quebec Superior Court found, Bill 21 also violates democratic rights by preventing individuals who wear religious symbols from serving in the National Assembly. That exclusion strikes at the heart of representative democracy. And Bill 21 also discriminates against religious minorities, and specifically creating unequal discriminatory effects on women who wear religious symbols as an expression of both their religious and gender identities, such as Muslim women. In particular, it creates this unequal impacts, so that's why we consider it to be discriminatory. The Quebec Superior Court also found that Bill 21 violates minority language rights in education. I'll get more into detail of the court decisions later, but I just want to outline that there's a lot of rights and freedoms that Bill 21 impacts. Ultimately, the broader legal question is whether the notwithstanding clause can be used to shield a law like this from meaningful constitutional scrutiny, and Anaïs will discuss this a bit shortly. But what I want to come back to is the impact. So now that we know what rights and freedoms are engaged by Bill 21, I want to delve a bit more into what are the concrete impacts. So since Bill 21 came into force, many religious communities have experienced increased marginalization and exclusion in Quebec. The harmful effects of Bill 21 has disproportionately affected certain religious communities, visible religious communities, such as Muslim communities, in particular Muslim women who wear religious symbols or religious headscarves like hijabs, and members of the Sikh community, both men and women who wear turban, and members of the Jewish community, as well as racialized and newcomer communities. And what we've heard from many individuals whose careers have been stalled, we've heard that some people have left Quebec and others have chosen not to pursue public service at all and have been forced into private sector because they can't pursue their chosen profession in the public sector. Many community members have reported feeling less safe in public spaces. Some have reduced their own participation in civic and political life. And there have been documented incidences of verbal harassment, physical threats, and violence directed at some religious communities. Bill 21 sends a message to many religious communities that certain people do not belong in public institutions and that they cannot teach, lead, adjudicate, or serve while visibly practicing their faith. So ultimately it bars talented individuals from entering public service and advancing their careers, and it's also driving skilled and educated workforce out of the province. So, for example, a survey indicated that 73% of Muslim women in Quebec have considered leaving the province due to Bill 21. So this is an example that this is not neutrality, as Anaïs alluded to. This is exclusion, and it reshapes who gets to serve, teach, and lead in Quebec. So that is why we, the CCLA, along with our litigation partners, the NCCM and a teacher candidate at the time, challenged Bill 21. I will now hand it over to Anaïs, who will explain what I alluded to earlier about the notwithstanding clause and how a clearly discriminatory law like Bill 21 has been able to continue to operate.
Thank you, Harini. And I feel like Harini is making a very compelling case to the effect that Bill 21 is rights infringing and deeply harmful for many members of religious communities. So the question some people might ask is like, well, why is the CCLA up to the Supreme Court of Canada in order to strike down this legislation struck down? And the answer is because we're not able to get to this debate on the merits of the constitutional challenge because the notwithstanding clause have been invoked by the Quebec government. So let me walk you through the particularities of that aspect. In a regular situation, courts hearing constitutional challenges usually ask themselves two questions. First, does the law infringe rights guaranteed by the charters? And second, if so, has the state proven that this infringement is justified in the circumstances? So, for example, had the notwithstanding clause not been used in Bill 21, the debate would have focused on the impact of this legislation on the rights and the employment prospects of Quebecers who wear religious symbols. And then it's pretty obvious that a rights infringement would have been established. So the onus would have been on the shoulders of the Quebec government to prove that Bill 21 is a justified measure, and the government would have had to defend its own vision of state secularism. However, this is not the debate that will take place at the Supreme Court of Canada in a few days' time, because when adopting Bill 21, the Quebec government invoked the notwithstanding clause of both the Quebec and the Canadian charters of rights and freedoms. And if I can put this very simply, the notwithstanding clause is like a trump card, and no pun intended, but it prevents courts from striking down laws, even if they unjustifiably infringe some important charter rights. And according to the Quebec government, when a legislator invokes these clauses, laws are basically shielded from any form of judicial review. Now, the notwithstanding clause do not apply to all fundamental rights and freedoms enshrined, for example, in the Canadian Charter of Rights and Freedoms, but it does apply to many of the most basic, essential principles that we need in order to live in a democracy and in a society that is truly free and democratic. So these rights that are subject to the notwithstanding clause include freedom of expression, the right to life, liberty and security of the person, equality rights, and the presumption of innocence. So in the context of the Bill 21 challenge, what the Supreme Court of Canada will have to opine on is whether there are limits to how the notwithstanding clause of the Canadian Charter of Rights and Freedoms can be used. So, for example, could a government invoke it to ban abortion or to criminalize political speech critical of the government or to legalize torture? If you follow the Quebec government's logic, even in such cases, courts would not only be powerless, but they would also be bound to silence. So if you ask me, and if you ask anybody at the CCLA, this is simply spine-chilling, and this is one of the many reasons why we're taking this case to the Supreme Court of Canada. So Harini will now tell you more about what we plan to argue at the SCC.
So as Anaïs mentioned, the use of the notwithstanding clause of both the Quebec and the Canadian Charters of Rights and Freedom, it's impacted the types of arguments that we're able to make at the Supreme Court of Canada or throughout the whole actual legal proceeding. So I'm now going to provide an overview of the road to the Supreme Court of Canada. So immediately after Bill 21 was passed, CCLA, along with our litigation partners, the National Council of Canadian Muslims, and a Muslim woman who was a teacher candidate at the time, Madame Hath, launched this legal challenge. And our position was clear. The notwithstanding clause does not place a law entirely beyond the constitutional scrutiny of the courts. Our Constitution is built on checks and balances among the executive, the legislative, and judicial branches. And the courts play an essential role in ensuring that governments act within those constitutional limits. So throughout, from the beginning of this case, we've raised two key constitutional arguments in support of our challenge. So the first one, and I want you to remember that what Annie said, like we couldn't rely on typical charter arguments because of the use of notwithstanding clause. So we had to think about other arguments that could strike down this law as being unconstitutional. So the first is that Bill 21 violates what we call the architecture or structure of the Constitution by limiting those who wear religious symbols from being able to participate in public institutions. So the public service is like those jobs are part of public institutions that serve the public. And a principle of democracy and respect for minority rights extends beyond the rights guaranteed by the Charter, and they're foundational to our constitutional order. So participation in these vital public institutions are key pillars of our democratic and inclusive society. And so a law, the crux of our argument is that a law that systemically excludes religious communities, visible religious communities from public roles undermines that structure. So that's our first argument. The second is that Bill 21 is beyond the jurisdiction of the province. So the legal term for this is ultra vires. And here we argue that the province is in effect attempting to regulate morality or fundamental social values by imposing a model of state-enforced secularism backed by prohibitive provisions that punish with penalties, an area that falls within the federal criminal law power. So this is a jurisdictional argument that Bill 21, because it's trying to regulate morality through secularism, that it is actually a domain of criminal law powers, which is a federal comes under federal jurisdiction. So these are very technical legal arguments, and you can read more about them in our factums if you're interested. I'm going to now walk you through some of the court decisions and the lead up to the Supreme Court of Canada. So there was a partial victory in a very complex decision by the Quebec Superior Court that recognized the inordinate harms done to individuals who wear religious symbols and struck down parts of Bill 21 as unconstitutional. So this is now the lower court, the court of first instance. And that court ruled that Bill 21 cannot apply to English language school board due to the constitutional protection to minority language rights, which is Section 23 in the Charter, and that the law was also deemed to be inapplicable to members of the Quebec National Assembly. And that is under Section 3 of the Charter, which guarantees democratic rights. However, the Superior Court decision also kept most of the law intact and many of the recognized harms in place. So both parties, so all of the parties, sorry, not both, there's multiple parties involved in this challenge. So all the parties appealed this decision to the Quebec Court of Appeal, which was the next level of court to look at this case. So this brings us to the Quebec Court of Appeal, and in a disappointing decision, the Court of Appeal upheld the validity of most of Bill 21. And unfortunately, the Court of Appeal decision also undid some of the limited victories that were obtained at the previous lower court, which had struck down some parts of the law as unconstitutional. So specifically, the lower court found that, as I said, the lower court found that Bill 21 couldn't apply to English language school boards due to the protection of minority language rights. The Court of Appeal in Quebec reversed that ruling, and it failed to really recognize the harms done to individuals in schools and teachers and education workers who wear religious symbols, who want to engage in the profession of teaching, and whose options are limited by Bill 21. A small silver lining in that Quebec Court of Appeal ruling is that thankfully the Court of Appeal agreed with the lower court decision that Bill 21 violates democratic rights and kept that ruling intact and said it would be inapplicable to members of the National Assembly itself. However, the decision by the Court of Appeal was a blow to rights and freedoms of Quebecers and a setback to equality, justice, and freedom in Canada. And so that takes us to to where we are in terms of appealing to the Supreme Court of Canada. But before we go to that, I want to hand it over to Anaïs, who will tell you more about the positions that were taken by other parties, specifically the Quebec government, and then we'll wrap up with explaining some of the significance of the case at the Supreme Court.
So thank you, Harini. And yeah, obviously this is a case that has generated a lot of interest. So just a quick, some data. We have a historic number of interveners at the Supreme Court of Canada. Almost 50 interveners have either been granted leave to intervene or they were interveners as of right, for example, Attorney General from other provinces and also the federal level. What's interesting when you look at the various facta that have been filed is that the interveners are taking very different positions through various lenses. So it's really going to be a very rich debate. Many interveners agree with the CCLA that there must be limits to how the notwithstanding clause is used, but they raise additional charter provisions that could be used by the Supreme Court of Canada to ground these limits. So for example, Section 27 of the charter, which enshrines Canada's historic commitment to multiculturalism and is not subject to the notwithstanding clause. So some parties are arguing that there could be a limit to the notwithstanding clause within that provision. Also Section 28 of the Charter, which could be seen as providing substantive guarantee of gender equality, could be, and again, a provision that is not subject to the notwithstanding clause. So some parties are arguing that it could be used by the Supreme Court of Canada. Also, some interveners are raising arguments grounded in Canada's obligations under international law. And there are also other interveners that agree with the AGQ, so the Attorney General of Quebec, that the notwithstanding clause can be used even in these circumstances. But these interveners argue that some of these interveners argue that some remedies should still be available. So for example, some argue that courts should still be able to issue a declaratory relief, which means to declare that had the notwithstanding clause not been used, the law would have been struck down. And this can look very intangible and not very helpful for a court to just issue such a declaration but not be able to strike down the legislation. But such a declaration would carry a lot of weight. It would be a helpful way to enlighten the electorate, who can then choose to vote a government out if they disagree with a legislation that has been passed. And personally, being a Quebecer, I think it's something that would be very helpful for the population, because right now there's this disbalance because the Quebec government says, no, this law is justified, but I don't have the courage to defend it in front of the courts. And courts must remain silent. They can't tell whether or not rights are infringed in an unjustifiable way. So I truly believe that if Quebecers knew the extent of the harms caused by Bill 21, we would be having a whole different conversation as the next elections are looming. Other interveners are also arguing that charter damages should be available even if the notwithstanding clause has been invoked. So there wouldn't be a systemic remedy in forms of striking down legislation, but individuals harmed would still be able to get some level of compensation, which wouldn't be perfect, but which is an argument. And of course, some interveners agree completely with the AGQ that the only limits to the use of the notwithstanding clause are those provided under Section 33, which are basically just procedural limits, but not really limits on how far substantively the government can go. So this is kind of just an overview of the very rich and diverse and complex debate that will take place in a few weeks at the Supreme Court of Canada. And switching gears a little bit and leading into a conclusion, and afterwards we'll be very interested to hear your questions and your thoughts about this presentation. But what we tried to do today is to give you an overview of why this case is so special and which issues are and are not before the Supreme Court of Canada and why. And I hope you perceive from our interest that we at the CCLA are very proud of this challenge and of all the work we've put into it. And we truly believe that this is the kind of challenges that is worth getting in front of the Supreme Court of Canada and having a decision about. But having said all of this, and without removing any of the importance of the case at the Supreme Court of Canada, We also believe that the issue of the growing use of the notwithstanding clause is probably something that will not be completely resolved in court. Yes, we truly hope that the Supreme Court of Canada will confirm that written and unwritten principles of our constitutions limit, in some ways, the use of the notwithstanding clause. But this clause is enshrined in our constitution. It will continue to exist, and governments will continue to be tempted to use it. And that's why at the CCLA, we've developed what we call a multifaceted approach to this issue. And part of our advocacy work during the past few years has been to try to convince federal and provincial legislators to proactively limit their own use of the notwithstanding clause. So obviously, it's always an uphill battle to try to convince the state to voluntarily and proactively abandon some of its powers. But we believe that here, this conversation is more than required when we look at the growing use of the notwithstanding clause. Yes, in Quebec, and Harini is going to give you more background and context with respect to this in a few moments, but also elsewhere in Canada. We're talking about Ontario, where the clause has been invoked, Alberta, Saskatchewan. So we're really seeing this trend of legislatures using the notwithstanding clause to deprive, I would say, vulnerable or marginalized groups from their rights. And this needs to be met with a political cost that will only come if the population truly understands the harms that can be caused by this clause. And as I was saying, part of the solution could be to have legislators pledge either not to use the notwithstanding clause or to only use it within certain parameters. And while we have a national campaign going on, and we'll be sharing the link at the end of the conversation, we can already see that some of the work we've been doing is bearing fruit. For example, at the federal level, and we're doing this work, but many other groups are as well, so I don't want to make it seem as if we were the only ones involved in this fight. But at the federal level, Senator Harder introduced Bill S-218, which would add procedural limits to how the federal government could invoke the notwithstanding clause. Now, the notwithstanding clause has never been used by the federal government, so it's not a pressing issue at the federal stage, but it's still a very interesting initiative and conversation to be had at the national stage. In Manitoba, there's Bill 50 that has been put forward by the government, and the government has moved to limit how its own legislature could use the notwithstanding clause. There would be no preemptive use. And in Quebec, we haven't heard from political parties, and certainly not the Quebec government at the moment, but the Quebec Bar has recently suggested procedural and substantive limits to the use of the notwithstanding clause. So in this electoral year, there will be provincial elections in Quebec in a few months. It's very interesting to see how political parties will respond to the growing pressure from civil society groups to limit how the notwithstanding clause is used. So I will now leave it to Harini to bring this home.
Thank you so much, Anaïs, for that really comprehensive pitch on the dangers and the increasing use of the notwithstanding clause and the normalization of it. So I wanted to now take some time to situate the legal challenge of Bill 21 in this moment in time that we're in. So since Bill 21 has been enacted more than 6 years ago and debated and discussed in classrooms, courtrooms, and town halls, there have been other measures that the Quebec government has instituted to further entrench or extend the objectives of Bill 21 into other areas. So in 2023, the Minister of Education in Quebec introduced a directive prohibiting prayer spaces in classrooms. CCLA is actually currently challenging that measure, and due to the ongoing case in Bill 21, that challenge has kind of stagnated a bit. In the summer of 2025, the Quebec government passed Bill 84, creating a framework for national integration grounded in a particular conception of Quebec culture and secularism. In the fall of 2025, the government passed Bill 94, extending the ban on wearing religious symbols to support staff in public education institutions, or public schools. Also in 2025, the government introduced Bill 9, which among other things proposes to extend restrictions of Bill 21 to daycare staff, subsidize private schools, restrict collective religious practices in public institutions, and significantly limit religious accommodations. And this bill is still before the National Assembly and hasn't been passed yet. But it is a dangerous proposal. In this landscape, the harms of Bill 21 and the case that we're taking to the Supreme Court become even more significant. 4 days are scheduled for this hearing. As Annie said, there's a record number of interveners participating in this case who want to have a say in presenting legal arguments on this constitutional issues that are at stake here. And the hearing is scheduled for March 23rd, that week, in 2026. So just a few short weeks away. And that this case, like at the heart of this case, is whether fundamental rights and freedom, which are core aspects of our democracy, have any real meaning, or if the rights can be so easily taken away. It raises fundamental questions about the role of courts in protecting democracy, rights and freedoms, and constitutional governance. And here's where you as the public come to play. The public has an important role to play in ensuring that rights and freedoms are protected by continuing to be informed about what's at stake in important cases like Bill 21, but also other cases where governments are infringing rights and freedoms. Supporting advocacy of groups like CCLA that challenge these types of laws and government actions, and continuing to be vocal about the importance of safeguarding our fundamental rights and freedom. So we urge you to follow the CCLA to be kept informed about this case at the Supreme Court of Canada and upcoming initiatives to put power back into the hands of the people and make the notwithstanding clause an issue each and every time it's used by government. CCLA has launched a public awareness campaign to make sure that everyone knows about the significance and importance of Bill 21 at the Supreme Court. We're just a few weeks away from the hearing. You can watch and share these resources within your networks to spread awareness about the importance of this legal challenge to Bill 21, not just in Quebec and not just about religious freedom, but the importance that this case will have across Canada and the widespread impact it's going to have on rights and freedoms everywhere. So thank you so much. And I think we are ready to open up the floor to questions. So I'll ask Michael to ask us, to see if there's any questions from the audience.
Perfect. Thank you, Harini. And yes, I'll be sharing some links in the chat for some resources that you can check out for our Build 21 page and our Save Our Charter campaign. So just look in the chat and I'll share some things on our website you can check out. But for the first question, if the Supreme Court rules that Bill 21 is constitutional and can stand as law, do you have plans for any further work on religious freedom in Quebec after that?
So sorry, can you read the question again?
Sorry, if the Supreme Court rules that Bill 21 is constitutional and can stand as law, do you have any plans for further work on religious freedom in Quebec?
Okay.
Yeah.
Yeah. So the Supreme Court of Canada is the highest court in the country. So if they do find that Bill 21 is constitutional, domestically, that's the end of the road, right? Like there's no other further court that in Canada that we can appeal to. We do have other ways to safeguard, like the one thing that we didn't mention about the notwithstanding clause is that there is a 5-year sunset clause for it. So it has to be renewed every 5 years. And so why this becomes important is because the only way then to really the pressure moves from legal options into public and political advocacy, where it's up to the electorate to send strong messages through the ballot box that we don't think that these types of laws are the types of laws that should be in a society that we want to be a part of. And they have to make that voice heard through elections and ensuring that, governments are held accountable at the ballot box for passing unconstitutional legislation that violates important fundamental charter rights, and using the notwithstanding clause to do so. So I think the other thing is that we do have some other litigation around religious freedoms that will be impacted by Bill 21. So, for example, the case on the Quebec prayer bans in schools, that one will also be affected. So we would be very limited in how we could proceed with existing cases that where the notwithstanding clause is used if this and it depends on what the court actually rules and says. But if Bill 21 is found to be constitutional, it really moves from a legal kind of battle into a political advocacy type of battle. Anaïs, do you have anything further to add?
No, I agree completely. My initial thought was to say, well, we'll never stop advocating for religious freedoms and the freedom of expression and people's right to equality, but we will have to take this fight to another, I would say, forum, which won't be in front of the courts if the Supreme Court of Canada does not follow us in the Bill 21 challenge.
And you can see some of our advocates work in our campaigns on Bill 21 with our social media campaign, our Save Our Charter campaign, which has been going on for over a year now. So I've just linked those two on our website if you want to go and check them out. They're in the chat, and we encourage you. So the next question we have is, sorry, just give me 1 second, it's from an audience member who's asking, on a different but related topic, is the CCL aware of Bill 50 in Manitoba that was introduced last fall? And will we be advocating for it to be reintroduced in the spring session with possibly better guardrails?
Yes, so I alluded to this bill very quickly. So yes, it was tabled in Manitoba. To my understanding, it's still at second reading, hasn't been adopted yet. It's interesting because they're adding, this bill would add a procedural safeguard, which requires that courts essentially opine on the constitutionality of a legislation before the notwithstanding clause would be used. So there would be no, as we call it in legal terms, preemptive use of the notwithstanding clause. So that would be very important, first, because we feel like the legislator would abide by its constitutional duty to try to legislate in a way that is charter compliant. Also, it would inform the electorate of the impacts of the legislation. However, it's not a solution that would be perfect because there wouldn't be substantive limits to how the notwithstanding clause could be used. So I agree with this audience member that there should be additional safeguards put in place, but it's definitely a good way to start the reflection. And if you look at the links that Michael has added in the chat, you will have CCLA's proposal about the types of parameters that could be put in place to make sure that the notwithstanding clause is not used in a way that egregiously attacks the rights and freedoms of groups.
Right. We had a couple audience members just raise their hands. So I'll just remind everybody, if you have a question to ask, the way to ask it today in this kind of webinar is to put in the Q&A chat. We're just trying to work through as many as possible, but we do have another 20 or so minutes to try and get through as many questions. So please, if you have a question about what you've been seeing, just put it in your in the chat and we'll try and get to it. So on to the next question. This question reads, I may have missed this point earlier and apologize if you already have covered it. But the Supreme Court rules that if the Supreme Court rules that the notwithstanding clause cannot be used in this way, how will it affect other provinces who have been using the notwithstanding clause to pass legislation? Are their laws automatically invalid, or do they have to fight one? Each has to be dealt with kind of separately through the court system.
So yes, definitely the decision by the Supreme Court of Canada, a decision saying that there are limits to how this notwithstanding clause can be used, would have a very important impact on other legislation, but the impact would not be automatic. It would either be that the government would repeal its legislation, but if the government chooses not to do that, we would have a distinct challenge would need to be brought forward in front of the courts and could go up to the Supreme Court of Canada again.
And just to add to that, like the ruling though from the Supreme Court of Canada has what's called precedential value. So it would influence as those other cases come forward and up the chain. If it's very it depends on how similar like the laws are and what the the court actually ends up ruling on this, but it would have to be applied. The precedential value of a Supreme Court decision is what makes this so significant as a case, because it carries weight in other provinces as well, but it has to go through the court system.
Okay. So the next question is asking, if all religious symbols are banned, what about Christian crosses? There are many public places in Quebec that have crosses, and are people allowed to wear Christian crosses?
Well, technically, if you're a public servant who falls within the categories listed under Bill 21, you shouldn't wear, you're not technically not allowed to wear at work a Christian cross. The reality is, I don't know how strictly that's enforced. And also, it's very easy for anybody who wants to wear that cross to just hide it under their shirt, which is not the reality of other members of other religious communities who have very visible religious symbols that they also have to wear as part of their faith, of their understanding of their faith and their sincere beliefs. But yes, technically a cross falls under Bill 21. Now, Bill 21 doesn't apply to the entire, like, being in public in any circumstances. So there are limits. It's really limited to public servants who are in a position of authority. However, as mentioned by Harini, this ban is progressively broadening to employees, school staff in the public sector. And then Bill 9, it's suggesting to also expand the ban to daycare workers and to teachers in subsidized private schools. So you can see how the reach of Bill 21 and this egregious ban is slowly expanding, but not to any public space right now.
And I just wanted to add to that, like to what Anaïs said, that this also demonstrates like the discriminatory aspect, like the Section 15 discriminatory aspect of Bill 21, where visible religious communities wearing visible religious symbol are disproportionately impacted by Bill 21. So something that we didn't get to talk about is, like, the law is on its face seems to be neutral. It prohibits all religious symbols, but the impact of the law has a disproportionate impact on visible religious communities where, the symbol can't be so easily hidden, and it's part of, it's very visible, it's part of their identity. And so that's the discriminatory impact that we're seeing with Bill 21.
Okay. And is there any is this happening in other provinces like New Brunswick? This question asks New Brunswick specifically, but are any other provinces in Canada or territories that this is happening?
To my knowledge, I don't see anything specific to religious, like this type of Bill 21 in other provinces. There are the use of the notwithstanding clause, though, to violate fundamental rights and freedoms is prevalent in other provinces. As Anaïs said, we're seeing that in, well, we've already seen it in Saskatchewan and Alberta, used to infringe rights and freedoms of trans and gender diverse students and young people in those provinces, and also in Alberta to restrict the rights of teachers to strike and engage in their collective bargaining rights. So we are seeing that across different provinces. Obviously, there's also there's also governments that or actions that restrict religious freedoms in other ways, but nothing to the extent of Bill 21 that we've seen in other provinces. Anaïs, you may have.
No, I agree.
Okay, so why does this clause exist, the notwithstanding clause, if it's so dangerous and can be used in this way?
Yeah, that's such a good question. The easy answer is that it was a political compromise. So back when the charter was being negotiated between the federal government and other provinces, there were two camps. The federal government and some provinces agreed that a charter of rights and freedoms should be enacted, and that this would mean that courts would have the last say over whether or not a legislation can operate in Canada and is valid. Some other provinces, including Quebec, believed that the legislature, so essentially the government, should have the last say, and that there should be no charter of rights and freedoms that essentially it goes beyond, has a supra-legislative value. And that conflict was resolved by a compromise, which is the notwithstanding clause, which essentially means that fundamental rights and freedoms and guaranteed under the Canadian Charter have a constitutional value and cannot be overridden by governments unless they use the notwithstanding clause. So it's kind of a safety valve that was put in place. The understanding when it was negotiated, so people who negotiated it understood that it would be used in exceptional circumstances when a government would want to override a essentially bad court decision that would be limiting the government's valid purposes or valid objective. And for many years, it remained like that, except for Quebec, where there very quickly was a symbolic use of the notwithstanding clause. And through the years, there was more uses of the notwithstanding clause. The rest of Canada, there was basically essentially no use of the notwithstanding clause for almost 40 years. But I would say in the last 5 to 6 to 7 years or so, there's been a huge increase in the use of the notwithstanding clause. So this initial understanding that there would be such a high political cost tied to any invocation of the clause, so much so that no government would dare using it because it would look as if they're admitting that they're overriding the rights and freedoms of their population, and that would be intolerable to the electorate. Well, this political cost doesn't seem to be materializing nowadays, and that's part of the advocacy work that we have undertaken. So we want to restore the political cost that was supposed to be tied to any invocation of the clause. Harini, I don't know.
Yeah, I think it's also important to note that the notwithstanding clause is a very unique Canadian thing. No other constitutional democracy has anything like that. There are limits. So like we have Section 1 that provides the justification and some limits on rights. There are other constitutions that have that, like some kind of limits, but nothing like this blanket override. There's no other constitutional democracy in the world that has that kind of blanket ban. Oh, sorry, not blanket ban, blanket like override on like constitutional rights and freedoms.
So this next question is about Quebec's Bill 94, and they're asking, was the notwithstanding clause used to invoke Bill 94, and can that bill be challenged?
So yes, the notwithstanding clause was used. So all of those 94, Bill 84, and Bill 99 also invoke the notwithstanding clause. So we are challenging at the moment the Quebec prayer ban. It was a directive at the time, but Bill, I've now confused which ones, but I think it's Bill 94 enacted, codified that prayer ban directive and into law, and then invoked the notwithstanding clause on it. And so that has impacted that litigation and that case going forward. The other thing that might be interesting to note is that you have to pass the law. This is what's interesting. When the directive is a policy, it's not enacted, and so that the notwithstanding clause is not applicable to that. The notwithstanding clause is only applicable to laws that are passed by a parliament, so the federal or provincial parliament. So that's also something interesting to note. And so it was used to pass Bill 94, 84, and 9.
Thanks, Hardy. And this is just a quick question. Will the trial or the Supreme Court kind of hearing on it be live on any media outlets?
So yes, there's a webcast. So if you go to the Supreme Court of Canada, actually all of their hearings are a webcast unless there's a publication ban for that particular case. But you can go onto the Supreme Court of Canada's website and you can live stream all of their hearings. It's a really interesting public education tool to learn about our court systems, and it's actually a fantastic website and resource. So again, for those who are interested, the Bill 21 hearing will start on March 23rd. There's 4 days of hearings scheduled. It says 9:30 is the start time, so you can log in. Might be a few minutes late, getting everything in court in order, but it should air shortly after 9:30.
I've just actually shared the link now in the chat too, so you can go if you want to watch. It's going to be there in the chat. Just use that link. So this is a two-parter. Did the lower Quebec courts rule on the right of the court to provide declaratory relief despite the notwithstanding clause having been invoked? And two, has that issue been addressed in courts in other provinces?
So I will start it, and then Anaïs, feel free to add. So in the Bill 21 case, the court did not specifically address the issue of declaratory relief. It has been addressed they did, but they came up with a different ruling. It was addressed in the You Are Pride case, which is another case in Saskatchewan, where the Saskatchewan government invoked the notwithstanding clause on a law that restricts trans and gender diverse students from using their pronouns in that case. And in that case, the Saskatchewan court did say that that the courts are allowed to use that the courts have authority to declare that a law violates charter rights, even though they can't do anything or enforce a remedy to invalidate its operations. And so we have a little bit of a disconnect between what the Quebec Court of Appeal is saying and what the Saskatchewan Court of Appeal is saying. And so that's why another reason why going up to the Supreme Court becomes very important, so that we can have some clarity at the national level on what is the appropriate whether declaratory reliefs or other remedies are available when a government invokes the notwithstanding clause. Anaïs, do you have anything to add?
No, that's very comprehensive.
Okay, good.
Michael, you're muted, unfortunately.
Sorry about that. Sorry. Can the provincial government bring the law in again, or a version of it after it's struck down, or if it's struck down by Supreme Court?
Well, it depends. I mean, if the Supreme Court of Canada finds that the legislation as drafted goes against the constitutional architecture of Canada and strikes it down for that reason, the same legislation, a legislator could adopt it, but it would be struck down essentially immediately by courts based on this binding precedent. Now, depending on how the Supreme Court of Canada will frame its reasons, there's definitely ways in which a legislator could try to circumvent the Supreme Court of Canada findings and adopt a similar legislation. And that's why watchdog for civil liberties, such as CCLA, are so important.
And this is a good question about watchdogs too, because it's asking if any organizations in Quebec specifically have provided a framework for consolidating advocacy to overturn this legislation.
Well, that's a very good question. I mean, the Quebec civil society is very active right now, fighting a host of rights infringing bills and laws. I could think, for example, of the Ligue des droits et libertés, who's very active in Quebec and is in many ways a leader in Quebec in the fight against Bill 21 and other so-called secularism bills. And there are also various other very interesting groups, such as the Observatoire sur les inégalités raciales au Québec, who are true leaders taking public positions on the issue. The Commission des droits de la personne also publicly voiced a lot of concerns about Bill 21, Bill 94, Bill 9. So, I mean, there are a lot of actors active in Quebec. And yes, we're talking to each other and trying to be organized and to mobilize together. So there are, for example, when it comes to Bill 1, the Constitution bill that was put forward by the current Quebec government without any consultation whatsoever, there is a broad coalition of hundreds of groups working together to urge the government to repeal this bill. So maybe if you follow the CCLA, if you follow the Ligue des Droits et Libertés, you'll be able to be kept in the loop about what's going on in Quebec and how to get involved.
I think this is a good point to remind people that we do have a French language webinar with the League tomorrow at noon. So if you want to join us there as well, you can. We're happy to see you. So next question, this will be the second to last question, just because we're running short on time. What impact does this have on Federal Bill C11?
C11?
Or sorry, C9. Sorry.
Oh, C9. Well, it doesn't have an impact on C9 because C9, which introduces amendments to the criminal code, does not invoke the notwithstanding clause. So that's a really distinct debate. However, it's always interesting to realize that whenever we hear of new bills that we deeply disagree with and that we feel our rights infringing and problematic, in many, many cases, a government could say, well, I don't care about what civil society has to say, and I don't care about what courts have to say. I can use the notwithstanding clause to override the right to liberty and to freedom of expression and the presumption of innocence and protections against cruel and unusual punishments, and equality rights. So I feel like it's a nice segue to remember this is not only a fight about the wearing of religious symbols as prohibited under Bill 21. This is also a broader fight about what threats the notwithstanding clause, as it's currently being used, pose to our democracy.
And the federal government has never used the notwithstanding clause today, but that doesn't mean that it can't happen in the future, right? So although this is around a provincial law that restricts religious symbol, there's nothing stopping a federal government in the future to use the notwithstanding clause to violate other rights and freedoms.
Okay, perfect. And this will be the last question. So apologies for everybody. We had a lot of questions. We had a lot of people show up today, so it's fantastic how people are engaged, and we do have the webinar tomorrow in the French if you're able to make it as well. So the last question, and I'll just pass it to you for any closing remarks you might have, is why isn't the notwithstanding clause being examined by the federal government or the Supreme Court? Or why is there not more of a push to reform it?
I'm sorry, to reform the notwithstanding clause?
They're just asking why is the federal government kind of tolerate the notwithstanding clause as it is if it's being kind of
because the federal government cannot, it's not their choice to tolerate or not to tolerate something that is enshrined within our constitution. So amending a constitution would be the constitution to remove the notwithstanding clause or to modify its content, its parameters, would require significant approval from various stakeholders, the federal government, yes, but various provinces as well. So it would be a very complex endeavor. And that's why our approach is pragmatic. We recognize that the notwithstanding clause exists. Now we believe that it is up to courts, to the Supreme Court of Canada, to explain how it can be used based on written and unwritten principles that already exist within our constitution. And in any way, we also believe that each legislature should proactively limit its own use of the notwithstanding clause. So yes, a constitutional amendment would theoretically be a solution, but it's something that is very unlikely to happen.
Thanks, Annie. So we're just going to have to end it there. So I'm just going to pass it back to you and Harini if you have any closing remarks before we end the webinar.
I just wanted to reiterate to look at the materials and the resources that we've assembled, the Save Our Charter campaign. There's a lot of questions on the notwithstanding clause. And so to learn about some of these initiatives and activities, not just from our organizations, but a lot of civil society organizations. One thing that we've been mobilizing, a lot of groups are mobilizing around these issues. And to also look at our work on the Bill 21 case. We just launched a campaign on Monday when it was 21 days to Bill 21. And we are going to be having a 4-part video series. The first video was released on Monday. Every week, we will release another video about the importance of Bill 21 at the Supreme Court of Canada, why we were challenging it, and what's at stake for rights and freedoms across Canada. So look out for those. If you don't already sign up for our newsletter, you can sign up on our website so you can get those videos into your inbox and get those resources at your fingertips.
Yeah, and just wanted to thank you all for the very interesting questions. We spend a lot of time working on these issues, but it's also really lovely whenever we engage with an audience to see how people are interested and interesting and engaged and willing to think these issues through. So just thank you for your time and your interest.
Okay, so I've just put the link to the French webinar tomorrow in the chat if anybody wants to sign up for that. So we're going to end it here. It's been fantastic. Thank you everybody for showing up. We had a lot of engagement, so we're really happy that all of you could come out. Sorry we didn't answer all of your questions if we didn't get to you. But yes, so just for housekeeping, this was recorded. We will be making these webinars available to you. So we'll send them to email if you registered, if you missed part of it or came late. So thank you for coming. We hope you keep checking out our stuff, work on CCL.org. If you can, donate. We're not government funded, so we rely entirely on people like you to support the work we do around Bill 21 and all our other work. And we're having more webinars. We're going to have one in Q2 in a couple of months. So sign up if you're on our mailing list. You'll hopefully hear about that, and we hope to see you out then there too. But we'll see some of you tomorrow. And for that, we'll end it here. Thank you. Bye.
Thank you.